Morning, Amanda.
Good morning, Simon. How are you?
Very well indeed. Who are our guests this week?
This week, we're chatting to Patrick Cannon, primarily specialises in SDLT transactions and has got lots to tell us about cases he's working on and work that's coming his way. We're also chatting to Rod, who we have met several times before and is a good colleague of ours and also runs his own podcast and actually introduced you and I to the very art of doing this. So we look forward to hearing from Rod.
Great stuff. So Patrick, did you want to start us off with SDLT?
Yes, Simon, thank you. And good morning to Amanda and Rod. Can I get a plug in first, Simon? From the beginning of this year, I've started the UK's first virtual set of tax chambers, canonchambers.co.uk. So I've left where I was, and so far it's very exciting, and I look forward to dealing with as many of you as possible in this coming year. So on SDLT, I've been asked to talk about a few current points of interest arising out of recent cases I've been involved in. And I should just say that the default position now with tax appeals is video hearings in the first tier tax tribunal. And I'm hoping also in the upper tribunal on appeal, although at the moment the judges in the upper tribunal seem to be rather resistant to virtual hearings for some reason. So as I'll mention in a minute, I've got a few appeals listed in March in the upper tribunal. At the moment, we may have to traipse down to London and go into that horrible courtroom in the basement of the Royal Courts of Justice, where the upper tribunal usually hears tax matters. Now, there are 2 points really to mention in relation to recent SDLT cases. And essentially they are multiple dwellings relief, which is a very hot topic at the moment because, of course, multiple dwellings relief gets the total amount of stamp duty down significantly if you can succeed in claiming it. And the other talking point is the classification of residential dwellings purchased with large amounts of land, whether they can be classed as mixed residential or non-residential use, or all the land surrounding the home is actually treated as residential, in which case the entire purchase is classed as residential. In the latter case, you pay eye-watering rates of stamp duty up to 15%, or from the 1st of April this year, of course, if you're a non-resident, 17% with the additional 2% surcharge. If you succeed in a mixed use claim, the top rate of stamp duty, of course, is 5%. Yeah. And that explains, of course, why there is so much activity around this and why HMRC are really resistant now to mixed use claims. I'll go into those in a minute. Looking first at multiple dwellings relief claims. Now, for those not entirely familiar with stamp duty, multiple dwellings relief is a relief that allows you, where you are purchasing 2 or more self-contained dwellings in a single transaction, to average the total amount of the price by the number of dwellings, and you only pay stamp duty at the rates appropriate to that average price. And then you multiply the amount you find by the number of dwellings to get the total amount of SDLT. Now that can bring the total SDLT payable on a purchase down significantly. And what I've noticed in cases I've done recently, is HMRC seeking to limit the scope of multiple dwellings relief on the purchase of a single residential building, which has been divided up into, say, an annex, with the rest of the building used as a main dwelling. There's been an awful lot of these claims. And the case I did most recently, a few weeks ago, involved a house in London that historically, since at least the 1960s, had been divided up and had what the occupants called a grace and favour apartment, which is a totally self-contained apartment, which you reached from the front door via its own separate doorbell, down a communal corridor, and you entered the grace and favour apartment behind an internal lockable door. And it had all the facilities: bathroom, kitchen, sleeping accommodation, living room. The rest of the house was divided into what was a self-contained dwelling at the back of the house behind a lockable internal door, where the family lived, and that had all the facilities. But the complicating factor in this case was that the occupants of the main dwelling also had access to separate bedrooms and a separate living area that were situated behind internal lockable doors off the communal corridor. Now, HMRC challenged the claim for multiple dwellings relief here. We claimed multiple dwellings relief for 2 dwellings because there are 2 self-contained dwellings in the property. But the argument that HMRC advanced was that because the occupants of the main annex also used the bedrooms, then, for example, putting the children to bed at night after they'd had their supper in the lockable main annex would involve bringing them down the corridor in their dressing gowns and putting them into the bedrooms behind the lockable doors. And there was a risk of them bumping into the occupants of the Grace and Favour Annex as they came and went about their business. That seemed to be the basis of the argument. On that basis, they said that in reality, this was really only 1 dwelling because the occupants of the main annex didn't have complete privacy. There are also a number of subsidiary points as well, which I haven't got time to go into here. We're waiting on the decision in that case, which should be fairly soon. I think I can say the name of the case because it is now a matter of public record, as it has been heard. It's Andrew Doe, DOE, against HMRC. And it's likely that whichever way the decision goes, there will be an appeal to the upper tribunal. But that illustrates, I think, the pressure that HMRC are now bringing to bear on making claims for single buildings that are divided up into separate annexes, trying to limit the scope of multiple dwellings relief. Now, the other talking point, and Simon, do stop me if I'm going on too long.
That's fine.
The other talking point on multiple dwellings relief, before I get to mixed use claims, the very hot topic surrounding refund claims, where the conveyancer has missed the opportunity to claim multiple dwellings relief on a recent purchase. And there are now many claims companies who are trawling the internet to spot property purchases where MDR could have been claimed. And they then write to the recent purchaser and say, look, we can make a claim for you. And that's generating a lot of refund claims. But the problem is you have 12 months to amend the SDLT return from the effective date of purchase. And you can do that to make a refund claim, and you'll normally get the refund paid automatically within about 25 working days. However, HMRC only get around to properly checking the claim, 8 months later, because I've got a 9-month inquiry period.
Yeah.
And a lot of people go and spend their refund check, and then are faced with a slight issue when HMRC come knocking saying, we don't think you're entitled to that. Let us have our money back, please, with interest. That's a side issue. The problem is refund claims older than 12 months. If you miss the 12-month amendment of SDLT return timeframe, there is a separate set of rules governing refund claims that allow you to make a refund claim within 4 years, but it's hedged about with restrictions. And HMRC brought those restrictions in around 2011, 2012. And for many years, the policy people who implemented these restrictions in legislation, amending the Finance Act 2003, apparently didn't tell their operational people. And so for many years, the operational people still happily gave refund payments up to 4 years without really questioning the allowability of those claims. Last year, HMRC got wise to this, and they started challenging refund claims older than 12 months because the restrictions are so great that most claims might fail under the rules that came in 2011, 2012, including where you say, well, there was a mistake. The return was filed on the basis of the understanding of the position at the time. Now, there was a recent case basically saying, in the first tier tribunal, saying you couldn't, it was very, very difficult to claim outside the normal 12-month period. And if your conveyancer made a mistake, then that was tough. Essentially, the implication was you need to claim against your conveyancer, not against HMRC, because they will reject the claim. Now that case was reported as a decision on the papers. In other words, there wasn't a hearing. It's called Smith Holmes 9 Limited. Now, the interesting thing about that case is that the taxpayer for whom I'm acting, and that they won't, I won't go into any great detail, but they will not object to me saying this. The taxpayer was not actually informed that the tribunal was going to go on and hear the case on the papers. All that the taxpayer had understood was that HMRC had applied to strike out their appeal for their claim beyond the 12-month period. The next thing they knew, there was a reported case saying their appeal had failed. So needless to say, we have launched an application to have the decision stood aside and the appeal reinstated and heard orally by video. And we will make a case there for the claim to be allowed outside the 12-month period. So the question, therefore, of claims made outside the 12-month amendment period is up in the air at the moment. And I would advise clients who are outside the 12-month period to put in a protective claim if they think they should have claimed for multiple dwellings relief and await the outcome of Smith Holmes. And I have a lot of, I'm sure others do, a lot of these claims older than 12 months that HMRC, when you call them up and say, what's happening with the claim? They say, oh, it's with the technical people, which is their language for saying it's waiting on Smith Holmes to be decided.
Sorry, Patrick, just going back to your, your original matter of Andrew Doe, do you think that if it wasn't internal lockable doors, so if there was a separate external door to the separate dwelling, that would make quite a significant difference? I mean, I'm thinking sort of some clients, when they talk to us about multiple dwelling relief, obviously, I think there's I don't know, seems to be a standard course with clients that are coming to us that talk about, you know, a separate garage, and they've got a separate dwelling over the top, and therefore a separate access.
Yes.
So would the separate access over the top of the garage sort of make a significant difference? Would an external door, in your example, would that make a significant difference?
Yes, it would. The crucial issue in a lot of these cases is whether the occupants of the main dwelling can keep the occupants of the annex out.
Right.
So if you have a communal hallway or a vestibule or something, where although the annex has a lockable external or internal door, if the occupants of the main dwelling area can't have total privacy from the occupants of the annex, then HMRC will reject the claim. And the other thing with regard, you mentioned accommodation above garages and so on. Another big issue at the moment is kitchens, and the presence of either a kitchen or at least the infrastructure necessary to reinstall or install a kitchen.
So a little more than a microwave and a kettle.
Well, I've got a series of, I think it's about 4 cases coming up. We tried to get them heard together, but HMRC objected. So we've got 4 separate cases coming up surrounding whether or not a microwave and a kettle, or whether the bathroom sink is enough to count as a kitchen sink as well, and that they'll be heard in the spring.
Right.
So that's another issue.
Interesting.
Kitchen is a very live issue.
Doesn't this?
Yes, certainly a front door is very helpful. Sorry, Rod. Yeah.
Doesn't it all come down to how people see the term dwelling or self-contained dwelling? Because we've had issues where we've had buildings that are houses in multiple occupation, but a specialist types that I think they're called Section 268s, which essentially means that they are self-contained units. They have cooking facilities in each unit. They have bathrooms as well, and but they do fall under an HMO. And the council will look at this, and let's say, for example, one of them didn't have bathroom and they had shared bathrooms. The council might look at that and say, well, that is technically a dwelling for council tax purposes, and then go through the valuation authority. And then when you go to HMRC, but the stamp duty department, you say, well, that is being classed as a dwelling. And they say, well, no, we don't class it as a dwelling, although the other department in the HMRC does, we don't, and therefore you must, you can't get your multiple dwellings relief. So we found it's quite tricky to work out which department classifies a dwelling.
That's a very good point, Rod. In fact, in the Fiander and Brower appeal last year, which was based on an internal corridor to the annex that had in the past had a lockable internal door, but that had been removed before the clients purchased. I took the tribunal through the definitions for council tax, VAT, and SDLT. And the council tax cases are very helpful because they, as you probably know, they refer to sort of units of accommodation rather than dwellings.
Well, it's habitable rooms as well as another one that comes up quite a bit.
Yes.
Yeah.
And on internal reviews, I have got, where I've seen the reviewer allow the claim on the basis of HMO and separate council tax.
Yeah.
But on appeal, the judges don't seem to be impressed by that.
Really?
And the Fiander and Brower case, which is under appeal to the upper tribunal, the judge was very against allowing multiple dwellings relief because of the lack of an internal door, even though a door could be installed very, very easily and very quickly.
It's a minefield.
It is, yes. So if I just complete my look at talking points on SDLT with just a quick mention of mixed use claims. For the first 16 years of SDLT, I was writing disclosure letters to HMRC on behalf of clients purchasing country homes surrounded by lots of land, saying we've classed this as mixed use. We paid the top rate of 5% because this land has more, this property has more land than is needed for the residential enjoyment of the dwelling. And I never got any pushback whatsoever. In October 19, HMRC decided, obviously enough was enough. Too many people were making these claims now, and they started pushing back. And the basic position that HMRC have adopted, and this has been supported in the Hyman case by Judge McKeever, is that all the land surrounding a dwelling is residential unless there's some commercial use occurring on it. Now, in my view, that overturns 16 years of practice based on their statements of practice in 2002 and 2003, which in my view was the correct interpretation of the law, i.e. that only the land that was necessary for the enjoyment of the dwelling was residential, the rest was non-residential, so you could make a mixed use claim. And the Hyman case, the Penfold case, Goodfellow and Miles Till are all found for HMRC. But the first three of those cases are on appeal to the upper tribunal in March this year. And essentially I will be arguing that the law as stated in SP, I think it's 103, is the correct interpretation of the law, and HMRC simply decided to, without any announcement, simply put out refreshed guidance in their manual in October 2019, and haven't even withdrawn those statements of practice formally. So it'll be interesting to see how we go. The resistance of the first tier tribunal to these claims was evident when my clients, I didn't represent the taxpayers in the first three of those cases. And they applied for permission to the first tier tribunal judge for an appeal. They refused. They then applied in writing to the upper tribunal for permission to appeal. That was refused. And then I got involved, and I had to go over to the RCJ and make a last ditch oral application for permission to appeal, because you actually get 3 bites of the cherry in these matters, thankfully. And I was ready for a real fight with HMRC on this. But to my slight surprise, it only took 10 minutes and we got the permission more or less there and then. And I don't think it was down to any magic that I brought to the party. I think the upper tribunal decided that this was a matter that really did need sorting out. And in March, they will give guidance to the first tier tax tribunal on the correct application of the law in this. But it's going to be really interesting. We've been set down for 3 days. So it's going to be a really interesting hearing. I'm really looking forward to it. So the only other point I'd mention with regard to SDLT, of course, from the 1st of April, we have this new 2% non-resident additional charge coming in. So the top rate can now be 17%, and it's a fiendishly complicated set of rules, particularly if you have a UK resident close company purchaser with at least one non-resident participator.
Is it a shareholding? So if, for example, one non-resident had under 25%, is there a cut-off of shareholding is probably what my question is. For example, if it's over 25, or is it based on the votes? Or
do you know, I looked at this in detail. I can't now remember, Rod, so that's a good question. I'd have to look that up. Yeah. But I do remember thinking the presence of one non-resident participator basically ruined the position.
Could be one
and attracted to 2%, yeah. Which is amazing, really. Okay, Simon. Well, that was what I thought I'd share with you. I mean, obviously,
That's great. No,
any further questions? Happy to
because
try
stamp
and
duty is overly complex, and of course we get a lot of inquiries on stamp duty. And what we find also is that a lot of conveyancers don't even bother claiming the MDR; they just stick it in,
No.
because they're too frightened now of the
SRA.
SRA.
Yeah.
So they try to force clients to pay too much stamp duty. I think we get involved to try and get it back.
Do you find you're giving advice that can be shared with the conveyancer to reassure them that it's okay to go ahead and make the claim?
I think it's often too late. Sorry.
Okay.
And conveyancers don't want to. They're not paid for it.
No.
I think now we're giving an advice letter to the conveyancer so they can then claim the relief on the return to get it right the first time now.
Yes.
It seems to be the way forward.
Yeah, because I think sort of solicitors are too scared, and they usually specifically state in their terms of business, we're not regulated to give tax advice, and this clearly falls into that bracket. And I think perhaps rather than going out and saying to the client, you need to get separate tax advice on this, see what possible reliefs are available to you, they simply say, no, this is not for us, and then hide, and then submit an SDLT one, and you pay the full amount. And I think that's the problem. That's where the bottleneck is.
Well, I've dealt with some clients who say, look, my conveyancer insists on just putting the return in on the basis of the full amount payable. And then they suggested you put in a refund claim.
Yeah.
Which to me is wrong. Get it right first time.
Yeah.
Yeah, to me makes sense. But anyway, we are where we are, and they are nervous creatures, are lawyers.
I've got a couple of questions. Sorry, Patrick. Just with if you're buying something and you exchange and you've got a delayed completion and you're doing works between the exchange and completion, there's obviously, with my developer hat on, I'm always looking to get a bit of a margin where I can. And the obvious one is to say, okay, I'm buying a house and I'm going to get control of that property and do works between exchange and completion and turn it into 3 flats.
Yeah.
There's a material change there. Now, isn't there a ruling whereby, although stamp duty is based on the completion date, if there is a material change to what's happened between exchange and completion, then it's based on exchange? Is that right? And if it is, what is a material change, and how do you kind of look at that?
You're absolutely right, Rod. The concept is of substantial performance.
That's it. Sorry.
Between exchange and completion. And one way you can substantially perform is to go into occupation, even under a license. So the trick is to draft if you don't want to substantially perform before completion, the trick is to draft the arrangements carefully so that the purchaser or his builder or whatever, or his curtain fitter, is going in for a very temporary purpose to do whatever they need to do. But obviously,
because there's reliefs on vacant properties for over a certain time and things like that. So that's very interesting.
You stray into an area where the builder goes in and is intended to knock the place down, rebuild a new one, and then subsell on.
Yeah.
And then you run into a horribly complicated provision called Section 44 capital A in the Finance Act 2003, which tries to deal with that and capture an SDLT charge on that situation. But of course, there may, coming up with the end of the stamp duty holiday, there may be a situation where you actually want to substantially perform before March the 31st, if it's not extended. So I'm expecting
to get around that.
And I'm sure we will all receive inquiries about people who want to exchange but can't complete until after the 31st of March, who want to lock into the holiday.
And I'm guessing, so with the home working thing at the moment, you've got lots of people working in their garage, and maybe if they're self-employed, and there's talk of the valuation authority now looking at that and saying, well, this is now a place of business. Is there then an argument for that to say, well, now this is non-residential stamp duty because we've got a premises, our garage, that is now being charged commercial business rates, and therefore, if we're going to sell it, the buyer will pay that.
I like your logic. I think in practice you'd have to have some form of third-party commercial use. Otherwise,
maybe if you're incorporating it to your company.
Well, yes. I mean, we can push the envelope, but I suspect the judges at the first-tier tribunal will be on HMRC's side.
And what are your thoughts on the stamp duty holiday? I mean, I know the government have said that it's definitely not being extended, but they have a tendency to do different things to what they say. Do you think there will be an extension, or do you think there could even be an overhaul of it, because it doesn't seem to have been working before the holiday? It seems to have had sort of dire effects, especially in areas like London. Do you think there's an overhaul coming, or would you expect that just they've got bigger fish to fry at the moment and that's way down on the list?
My hunch, for what it's worth, is that because of the lockdown 3 and the fact that the market has got used to this holiday, they'll probably extend it. But if I could be extremely cynical for a moment, if this current government says they're not going to do something, then on a Friday, then on a Monday, they do it.
We should get down the bookies every time.
Thank you. That's absolutely brilliant, is that? Rod, obviously you're a client and a colleague. So how do you start on a property? If you're a developer, an investor, you have a podcast, you run various mentoring schemes. So
don't say that. No, I don't. Consultancy scheme.
Sorry.
A mentor is someone that gives free advice. Unfortunately, mine's not free. I started probably how most people start, by buying their own home, and what I could afford at the time was not my dream house, and I tried to create my dream house by bodging it and making all the mistakes and doing everything cheaply. And fortunately, I think the market held up quite well, and after a year it was worth a bit more than when I bought it, and sold it and thought, well, if I maybe do that a little bit better and more efficiently, there's money to be made in this. And I suppose I because I was young, free and single, I was able to move house regularly until HMRC decided that actually this was a business. And I thought, well, okay, now I've got to kind of look at this properly. And at the time I had another business that I was running but didn't particularly enjoy. There's something very satisfying about creating something nice out of something not very nice. And that's what I did. And I'd go and buy properties at usually auction, not necessarily because it was cheap, but because the whole process was quicker. Buying a house, 1 in 3 property purchases fall through. The average time is God knows how many months. So that for me was the benefit of buying at auction. You knew where you stood, as long as you could kind of get your head around the basics of legal packs and understand what the problem is, because properties at auction normally have a problem. So as long as you understand how you can fix that problem, you could do that. And then I kind of just organically grew and got a bit braver as things went on, until I was kind of splitting houses into flats and buying commercial properties and turning them usually into flats. And I suppose I started trying to do the first developments in about 2007, which was not the best time, and managed to just about kind of stay alive through that, and just went from there. And then I got involved doing some modular builds, and got involved with a bigger private equity real estate firm, who I was really fortunate to spend some time with on some of their bigger schemes, and help them with those, and learned a huge amount. in terms of kind of the commercial side of it, really, how to increase value, not just through bricks and mortar, but through structuring leases in a sensible way, through securitizing income and that type of thing. And I found that side of things fascinating, and yeah, went from there. And at the moment, well, 2014 came around, which was really probably the peak of London property. And from there, I was based in London and would develop stuff here. And I just couldn't find anything that stacked up. There were tax changes at the time. There were changes to lending at the time, whereby if we wanted to go on to term lending, it was all suddenly based on the rental income rather than the loan to value. And where you've got lower yielding properties, such as the Southeast and London, it meant that you really only had one exit if you had development finance, and that exit was to sell. So if you couldn't sell, it meant you were not in a great position, as lots of developers found out post 2014 and have really struggled since in London. But I was fortunate enough to look at things and think, right, London is a bit too risky, and I started doing things in Manchester and Leeds, where I was focusing more on the investment side and looking at holding these properties. And so went up there and tried to build things, and realized very quickly that because the capital values are much lower and the build costs really remain about the same, especially if you're an outsider going to work, that it's very difficult to do that. And so rather than building things ground up, tended to convert commercial buildings, so you benefit from things like stamp duty, as Patrick's kind of discussed, and various things like that. And now I'm still looking at those northern sort of powerhouse areas, but I do feel that London's got some really good opportunities now. So again, starting to look at London now, and all the while we've just bought a portfolio in Scotland, as you know, and a large kind of, don't really know how to describe it. It's a cross between a business estate or an industrial estate in the East Midlands as well, which we're looking at. That's much more of an asset management play to, again, like I discussed, look at how we can structure the income there, and generate a bit more. And I run the RodCast, which is a podcast about property. The creative juices were really flowing the day we picked the name for that one, which you've been on several times and have been fantastic guests on. And that's really about a podcast all about property, business and investment. And it's great fun. As you guys know now, you get to speak to amazing people like Patrick, and it's just a fantastic excuse to have a good chat and really get a load of information from people who are specialists in their field. And I also started something called the Boardroom Club, which is really a consultancy service for small SME property business owners, whereby in property, it's often you don't have many people involved in a business that usually is with quite high numbers. So it's quite different to other businesses, and that's great if on some terms, but on other sides, it's quite difficult because it's quite a lonely business. It's quite difficult to sort of get your heads together and bounce ideas off each other. And really, we looked at it as taking the best parts of commercial, of the corporate world, and putting them into SME businesses and allowing them to kind of have a small network of peers that they can bounce ideas off and really be held to account for pushing that business forward. And that's something I do. It takes up about 2 days a month, so it's not a huge sort of commitment, but it's really good fun, and get a lot of enjoyment out of that. So that's something I do with Adam Lawrence, who I know has been on your show as well.
So how do you join the Boardroom Club? Did you approach you directly, or is it like...
Yeah. If people are interested, I mean, we only have 10 businesses on that at a time, so it's quite tight knit. But yeah, just you can get in touch, email me. I'm sure you'll put my contact details on the show notes. So if anyone is interested, yeah, feel free to get in touch.
Cool.
Yeah.
Good, yeah.
Don't know if there's any questions about that.
Yeah, I've got a question, Rod, if I may.
Of course, yeah.
Do you, in your development activities,
Mhm.
And it's interesting you're looking at central London again, have you come across derelict dwellings?
Yes, we do, and I probably know where you're going on this. So we do come across derelict dwellings, and we actually come across it not so much in London, but far more in places like Manchester.
Yeah.
And what we found with on the stamp duty side of things is, I can't remember who what the case was that kind of with the asbestos and
Yes, Bewley Homes.
Bewley, that's it. And it's what we found is it's always quite difficult to kind of know what constitutes how we can go about kind of getting that proven that it is not just vacant but not residential, because it's so far dilapidated, I suppose. Yeah, so that it's not fit for use. Because I remember at HMRC said, well, it doesn't matter if it's not fit for residential now, it's about if it could be fit. And then I think there was appeals, and I think I was lost before that, but that's what threw me. Yeah, but yeah, it's very interesting.
Yes, no, it's people are trying to push the envelope around those as well. So.
Yeah, well, look, I'm all for pushing the envelope. And again, we do a lot with probate stuff, so
yes,
probate can be quite good. That's always the problem we have especially in London. That's quite difficult because there's a cap on the works you can do to bring it back, and that can often be tricky. I know we always wanted to. I always discussed this with Simon, and he always said, no, you can't do that. And it always annoyed me. But in a group of companies, could you buy one in one and sell it to a linked company, and then they can carry on doing the work after you've done the maximum? But unfortunately, I think the intent there is probably a bit too far gone.
It's just the envelope becomes a parcel and you change it into a jiffy bag, and I say, no.
Absolutely, yeah.
Thanks, Rod. Thanks, Patrick. That was fascinating. Really, really good. Thank you to both. Thanks, guys.
Thank you both. Thank you.
Thanks for having us.